Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today I have two seasoned trial attorneys with me, Camille Abate and Kathleen Mullin. They are the authors of Advocacy Excellence, the Jury Trial Second Edition, which we will be talking about later in the podcast. But right now, I'd like to welcome them both and ask a little bit about how you became a trial attorney and what led you to your current roles. So, Camille, why don't we start with you?
Sure. Well, it's funny. I became a trial attorney. I went to law school actually to save the world. And that was I was very active politically in college. This was we're talking way back now. We're talking in the 70s, right after the Vietnam War. And I was very politically active. And I thought I would be like the Ralph Nader of law. Ralph Nader, who sues everybody was the one who sued car companies to make them put seatbelts in, and cigarette companies. And that kind of litigation was what I thought I wanted to do. But then I took the criminal defense clinic in law school and was assigned a couple of cases that were misdemeanors. And I just fell in love with the intensely personal side of criminal defense. The fact that there's some guy or woman who is looking to you to pull them out of the quicksand, if you will. And so I changed my point of view from civil public interest litigation to, what, I like saving people one at a time. This is going to sound funny, but I always consider myself like in The Princess Bride, the Dread Pirate Roberts. I was the one pulling the princess out of the quicksand, not the other way around. I get such a kick out of it. And as I became a trial lawyer, that high that you get from extracting people from difficult situations, when I say difficult, I mean really difficult situations, criminal situations, it's something that has motivated me and kept me going for 40 years now. Crazy it's that long.
That's terrific. And certainly many of us went to law school to save the world, and you certainly are saving it for all of those people that you're helping. We'll get back to your experience in a little bit, but thanks for sharing that. And thanks for the plug for your criminal law clinic in law school. As a clinician, I know how valuable and really transformative those clinical experiences can be in law school. And now, Kathleen, can you share a little bit about your journey to being a trial attorney and your current position as Deputy Director and Supervisory Trial Attorney with the Navy JAG Corporation Defense Counsel Assistance Program, which is a mouthful.
Yes, everything in the military gets reduced to an acronym. So everything has a tremendously long name. Thanks for having us, Dean. We really appreciate it. I have to say, you both are now sort of on my hero list because I did not go to law school to save the world. I went to law school because I grew up in a modest, low-income family, and I watched LA Law. And on LA Law, lawyers were not living in modest, low-income families. They had nice cars and nice houses.
Oh, they sure did.
I decided that I was going to go to become a lawyer so that I also could have a nice car and a nice house. And absolutely knew not even one person who was a lawyer, had no idea what was involved in it, and was completely blindsided by 1L and 2L life in UCC and tax and contracts. And by the time I reached the end of my second year at Boston University School of Law, I was despondent that I had completely misunderstood the entire thing and was prepared to make a pact with the economic devils that I would be poor the rest of my life if I just didn't have to go back to law school.
Oh my goodness.
And then I went back like Camille. I went back my third year and was admitted to the criminal clinic and was sent down to Boston District Court, City Court, to represent folks on the license of our professor who is still teaching at BU School of Law. And it was like somebody threw the lights on for me. It was like, now this is what I want to do. No one told me that public defenders are not the lawyers on LA Law. I didn't figure that out for many, many, many years to come, but it didn't matter because I learned about myself that I am not motivated by money. I am motivated by the great good principles in the Constitution that protect the little guy from the great white hot light of the government. And I, like Camille, am thrilled every time that little old me from little old nowhere gets to stand in the middle between John or Jane Q. Citizen and the United States government and tell the government, not today, not on my watch. So my criminal clinic experience is how I got where I am. And entertainingly, I now work for the government, but I work, the government is my employer. The United States Navy JAG Corps is my employer. My views on this podcast and everywhere else are my own and are not the views of the government. But the joke is I work for the government, but I work against the government by helping our lawyers in the JAG Corps to defend at the highest level service members who are charged with crimes under the Uniform Code of Military Justice.
So now you have both inspired me tremendously. I appreciate that story, and I know that law students will too. The idea that one of you found the clinic and that was your nirvana, and the other thought, the law school's not for me until they got to the clinic. We see both of those examples. But you both were doing criminal defense as not LA lawyers, right? You were a public defender, Kathleen, and Camille, you were at Legal Aid Society's criminal defense department. And so you started with modest, at least financial beginnings in your lawyering work, but it was passion and mission that kept you going in it. But one thing I wanted to ask about is, how was it with your nearly 60 years of experience between the two of you in trial work and on the criminal defense side? How was it doing trial work during those decades as women? Because at least my experience is in those decades, there were not a tremendous number of women going into criminal defense. Was that your experience? And if so, how did it color your professional career?
It wasn't at Legal Aid. When I started at Legal Aid, there were a number of women there as lawyers, and a number of them were mentors to me. But in the courts, we're talking 1982, 83, there were virtually no female judges. And the ones, I can think of one or two, and they were mocked all the time. And they would refer, we at Legal Aid did the same thing. We'd refer to the judges who were female by their first name, like Gloria Goldstein was very smart, very dynamic judge, not always great to the defense, but we used to say, oh, Gloria did this today. And we did never do that with the men judges. It was called them by their last name. Judge Schwartz did this, or Judge so-and-so did this. So, and I will tell you that the male judges were, looking back at, at the time, I knew it was not great. It was uncomfortable, but it was what was going on. They would make comments about women. One of my favorite senior attorneys was a gay woman, Edna Schwartz. Hi, Eddie, if you're listening. She was a great mentor to me, but she always wore pants. And judges would call our supervisor to take her out of the courtroom because she was wearing pants.
Oh, my goodness.
Yeah, just to take her out of the court because she was wearing pants. And I've had male judges tell me, take your hands out of your pockets. Or, Camille, you gained weight after when I got married and had a baby, you gained weight and you haven't lost the weight.
Oh my goodness.
Yeah, I mean, these are comments that, and then of course you'd go up to the bench off the record, they would say all kinds of crazy stuff. And they tended to try and talk over you a lot. Although I have to say, I never looked at it as I was a victim or anything. I would talk right back. My parents were Italians. My father was off the boat, and corporal punishment was the norm, and screaming was the norm in my family. And so when I first got to court and saw these judges, I said to my supervisor, I said, now, just let me get this straight. They can't hit me, right? Because if they could scream, no one could scream like my dad. So water off the duck's back. You want to scream at me? Go ahead, baby. It sounds like music to my ears compared to what I grew up with. So, they would try and cut you off, and I wouldn't let them cut me off. It was a challenge sometimes. I won't say all the time because I won a lot of cases. So I can't say the judges, I really didn't care what the judge thought of me. And that's been, and we say it in the book, right, Kathleen? That's been my mantra my whole career, which is that the true professional does what they have to do to get it done. And if that means making an unpopular motion or making a judge angry because you're objecting to everything, but it never bothered me. And the male judges would try and outshout you or put you down in some ways. It didn't work with me. But I look back on it now and I think, wow, that would never happen today. I mean, it was crazy. And of course, I had one woman professor in law school who told me she was the only woman in her law school class when she graduated. The only one.
Thankfully, that's changed a lot. Both the judicial appointments, the treatment by judges of women, at least from my experience, and then the majority of women in law schools now, ours included. Since 2018, we have more women entering than males. But Kathleen, did you have any similar experiences you wanted to share about being a woman in a largely male dominated community.
So Camille makes excellent points, right? And Camille and I both worked at the Legal Aid Society in Brooklyn, New York. And Camille was one of the women leading the way by the time I came in the early 90s. Camille had been there already quite a bit of time and had a reputation for being a very successful trial lawyer. So there were female mentors who, took the time to teach you what they had learned the hard way, right? So Camille being among them, and also Camille will remember our old colleague, Kelly Sharkey, who was a ferocious trial lawyer and took
Right.
me
Yep.
under her wing and taught me by letting me second chair trials with her. Margaret Cates, who is the federal public defender in New Mexico now, also just a dynamo in the courtroom. And, you could find people to emulate as a woman trial lawyer in those days. I'm going to add this thought for you both, and I'd be interested in your take. It may not be the world's most popular thought, but women do this job differently, and they can do it differently. And I think when I first started, as I've already confessed, much of my idea about how to be a lawyer came from trying to emulate what I saw on television. And so trying to copy what men were doing was an idea I had. And it wasn't too long before I figured out that, no, that's not going to help me. I bring a different way of thinking. Women think differently than men. I bring a different presence to the courtroom. I bring a different tone to my cross-examinations. So, sort of a young female lawyer going head to head, toe to toe with a very seasoned sort of NYPD detective, they look you over and decide a certain thing about you. And then it's up to you to sort of fix their wagon and not alienate your listeners so that you can win the case for your client. But in order to do that, you have to be authentically you, and you have to work every tool in your toolbox to the fullest extent possible. And if that means manipulating some one-dimensional man who has formed an opinion about you, which is baseless, and then manipulating him, urging him along to treat you in a certain way until a certain point in your cross-examination, when you euthanize him for the benefit of your client, then that's what you should do. And Camille and I talk about that in the book, about being authentic. You've got to bring every tool in your personal toolbox. And Camille and I do this job very differently, even though we're friends for decades already. We have different strengths and weaknesses, and we have different ways of approaching the same problem. But if I try to be Camille, I will go down in flames. As well as I know her, I cannot do what she can do. And so for anyone listening to us, being a woman in a courtroom back in the day when there were different attitudes towards us, okay. But being a woman in a courtroom in criminal defense today is a very empowering experience, because you can bring the great good wisdom and all of the skill that all the smart, canny, strong women that I know. You've had to get along in this world as a woman the whole way. There's no reason you should leave those skills at the door and try to emulate other people, male, female, non-binary. You should be who you are and bring all of that. And that's how you become the most successful advocate you can be.
That's extraordinary advice. And I'm glad that you covered that in the book. Let's go ahead and start talking about the book. So Advocacy Excellence, the Jury Trial, second edition. The second edition just came out in September of 24, so is available now. First edition was written in 2020. And what prompted you both to write the book?
Well, I started teaching at Brooklyn Law School as an adjunct in 2016. As Kathleen will tell you, we both had ways of doing things that were helpful to other attorneys. And so when I started teaching the criminal practice seminar at Brooklyn Law School and then the trial advocacy course, I wanted to give the students a very realistic experience. And I found that the only students who really knew anything about trying cases were those on moot court, but that the moot court program at Brooklyn Law School was not taught by, or was not supervised by a professor, but it was other students. So Brooklyn Law School has a moot court program where they have, as quote unquote supervisors, students who had been in the moot court program before. There were a lot of rote things that were done that were not effective advocacy. So I started building, and I did look at, I will say, I looked at other trial advocacy books, and they were all written very densely, very theoretically, not very practically. And I wanted to give my students the ability to, like, for example, practice in a simulated case the skill of direct examination or impeachment or jury voir dire. So I was looking for supporting materials that would help with that. I was not really satisfied with what was out there. And, it's funny because there was a point in time where I was at the Bronx Defenders, which is another public defender group, but I was there at a time I had run for Congress in 2008 and lost. So I had no money, so I had to go back to public defense. I couldn't support myself as a trial attorney right away after 2 years trying to run for office. So I had developed for the lawyers there, the newly admitted lawyers there, a series of exercises, cross exercises, direct exercises. I gave some talks on how to deal with jurors after deliberations, during deliberations when you can't talk anymore, all kinds of trial skills. And so as I was teaching at Brooklyn Law School, ironically, I got a call from what was then Wolters Kluwer's, now Aspen, and this is an Aspen book, saying that I had been recommended by the dean of the clinical education at Brooklyn Law School, Stacy Kaplow at the time, because they were looking for someone to write a book that was more modern, that had the e-discovery, for example, the smart courtrooms. And we're looking for someone who was experienced enough in that to write it. And so I was like, yeah, I'm willing to do it. But of course, was I willing to do it by myself? No. The first thing I did was call Kathleen. I was like, Kathleen, I need your help. I'm going to write a book. So that's how, but honestly, and Kathleen can attest to this too, we reviewed the other books, but we basically wrote, this was all our own material based on our experience. It wasn't based on, there's like case law, and you have to adhere to the law, and we have updates on the law in our second edition. But the point is, the actual skill set was based on what we did, what we were successful at, what we specialized at. And so the book is written from the point of view of our personal experience. And it's not stuffy. It's kind of like, all right, you want to do this? Here's what you do. Bump, 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 bump. Okay, you want to do this? Want to admit evidence? Here's what you do. Bump, 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 bump. And that's how we wrote it. And right, Kathleen? It was funny the way it came out based on what the people at Wolters Kluwer, now Aspen, said. It doesn't read like a text.
That's right. We literally started from a blank computer screen, and we said, we're going to take everything that we've lived and every mistake that we've made and been punished harshly for by judges or juries, and we're going to write about them, and we're going to help folks to not fall into those holes that we fell into. And Camille and I, whenever we go around teaching, I always say to the folks who are listening to us, like, I'm not a lawyer. The law has nothing to do with what I do for a living. I am an influencer of human decision making. I cause people to make a decision that they otherwise are not going to make unless I intervene. And so if you would like to be an influencer of human decision making, aka a trial lawyer, you need to know more about people. You need to know the law. There's no question about that. You need to know the law, but you need to know more about people than you think you do in order to influence their decision-making process. Make no mistake, if you want to be a criminal trial lawyer, the system is not designed to be an even playing field. It is a juggernaut designed to move your client from liberty to incarceration. And unless you, the fearless warrior trial lawyer, criminal defense attorney, get in the middle and do something about that, that is exactly what's going to happen. And Camille has an expression that we use. You don't want to be a competent loser. You don't want to be somebody who is competent enough that no one would ever say, well, they were unprepared or they don't know what they're doing. They would never say that about a competent loser. But the competent loser never wins. They don't know how to go far enough to influence the decision-making to bring home the result that they need for their client. So this book is about how to avoid being a competent loser and how to influence those humans at the right time in their decision-making so that they begin to see the facts the way that you are presenting them.
Well, I'm relieved you didn't call it How Not to Be a Competent Loser, because I think that would have not been as successful. Camille, you were going to add?
I was just going to say, just picking up on what Kathleen said, and it really is, I think, the difference between our textbook and a lot of the textbooks out there is that we want to have the law students learn how to win. Our textbook is basically focuses on the idea that you can win jury trials. And speaking to jurors is an important skill, but more to the point, it's not about just knowing how to do something. It's about knowing how to win. And I have to say, one of the things that really good trial lawyers know is that your adversary's case could look great on paper. You know, it looks unassailable on paper, but when you get a live witness on the witness stand, and I've seen it. How many times have I seen it? How many times, Kathleen, have you seen it where they look great on direct examination, but you start the cross-examination and then they start to just fall apart because no one's ever asked them the way you're asking them, or about something, or challenge them on something, or impeach them with an important piece of evidence. And the idea that it can go so awry is, if you look at just the paper, which is what I object to with a lot of the competent losers, is they look at, oh, this looks like it's a good case for the prosecution, it's a good case for the plaintiff. Well, no, you haven't seen anybody yet. You haven't heard anything. And I just, can I tell an anecdote? I mean, just
Sure.
my very first federal trial, I was retained because a old law school friend of mine had a paralegal whose nephew got involved in a terrible case. It was like a racketeering double murder, my first federal trial. And the feds always have cooperating witnesses, and they all sound great. Yes, I was there, I was a member of this gang, and I did this and he did this and blah 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 blah. And it just to show the human side of trial law, which shows that it's not really about law, not about lawyers, it's about trying a case. One of these cooperators was on the witness stand, and the feds love to make sure that they get all of the guy's record out. Yes, I did this, I robbed this, I did this, I stuck up this person, I'm a terrible person, but now I'm trying to pay back and pay my debt to society, and this guy was right there with me, and they get a benefit from that. But so this one guy at this trial, I'm listening to him, and he did some really horrible things in his life. I mean, it was like, from a human perspective, he's in a restaurant holding up the restaurant owner or manager in front of parents with children and eating lunch in the restaurant and all kinds of things like that. So when I got up to cross-examine, this was not part of my cross-examination, but I just couldn't resist asking him. It's like, you testified about all these horrible, violent things that you did. Did you ever consider selling drugs to make money instead of robbing people? Because it's a more non-violent way. I mean, why did you go this route? And you know what his answer is? His answer was, well, that's not exciting enough. It was like, oh, and then I was off to the races. My next question, oh, so you enjoy in front of a young child putting a gun to someone's head and blowing their brains out. You enjoy that. You enjoy the blood. You enjoy making people cry. And at that point, it's like we talk about the moral high ground in the book. The jury switched off. They were like, you know what? I'm not listening to you anymore. And my summation was basically, these guys they're sociopaths. They're psychopaths. You're going to find my client guilty because a psychopath said something. And that was, my guy was facing life because it was a racketeering double murder. My guy was the only one who did not fire a gun. And I won't get into the whole defense there, but there was a defense. But the point was, these cooperators who the government relies on almost exclusively, they looked great on paper. But when you get up on the witness stand and someone gives you a gift like that, oh, it's not, drugs not exciting enough. I mean, that's where the rubber meets the road. That's where what Kathleen's talking about, being yourself. That was a question. I was just curious. I wanted to know, why would you choose to do that, just from a human perspective? Because I am a human being and the jurors are human beings, and I'm talking to my fellow human beings here who were on the same page with me. Like, this is really horrible stuff. And it just,
that's a great story. Yeah. Well, the book, I know, is broken up into 3 parts. It's
by the way, can I interrupt you for 1 second?
Sure.
Just to say that in the book, you will find many stories like that.
Okay, good.
Because we have put those stories as examples in many of the chapters. Go ahead, sorry.
No problem. I know there's part 1 is focused on preparation, part 2 on practice, and part 3 on strategy. But one thing, in addition to the anecdotes and the question and answer examples that you have for every chapter, and the illustrations and charts, the sidebars with some cautions and practice tips, I know you've got timely coverage of the role of social media, and I wanted to ask about that specifically, quickly, because while many of the attorneys out there are probably getting more used to smart courtrooms, the role of social media is constantly evolving, and I know becoming even more problematic in trials because of not only where it can show you where you were or what you were doing, but emojis can have impact. So just if you could share kind of how you address the role of social media in jury trials in your book.
Sure, I'll go ahead and speak to that. So any criminal defense attorney in courtrooms today will tell you that the very first thing law enforcement does when they arrest your client is take their phone and dive into their social media. Also, any criminal defense attorney practicing today will tell you that on their own personal devices, they have passcodes and not biometrics, because law enforcement needs a warrant to get into my phone. They can't just hold it up to my face and get access. And all of the location services are turned off on all of my social media accounts so that there is no geo-tracking of where I am or where I'm going. But these are things you learn when you are a defense attorney and you've reviewed piles and piles and piles of discovery where people's whole lives are laid bare by social media and the devices that people carry. So we wanted to address, how do you handle that kind of evidence? Because there is nothing as powerful as someone's own words attached to a photo of them doing something that on the witness stand they are denying ever having done, than for you to show it to your listeners, your decision makers, from their social media account. So if you are defending against social media, there is a lot that you can do by way of narrowing the admissibility of social media posts, attacking authenticity. It goes to the foundation that the government's going to have to lay in order to get your client's social media presence, posts, etc., into evidence. So we discuss how you would go ahead litigating motions to suppress, how you go ahead and if you lose that motion to suppress in entirety, then you are making a motion to redact. And we are focused on relevance in that area. And then how to use social media affirmatively to support your client's alibi or the sort of presence or absence of someone or something at a particularly relevant time. There are ways that your digital forensic experts can teach you, which we have learned. If you have an incident which took place at a particular location, you can just go on, say, Instagram and search hashtag the name of the location. And any person who was at that location, who made a post that they tagged to that label, will show up. And when you look through those hundreds of photos, you may come upon a photo that shows your client or other relevant players or things at the location at the right time. So using social media, defending against the use of it against your client, and then using it to try to demonstrate on behalf of your client's defense an alibi or the presence or absence of something. We won a particularly notable case with our aggressive searching of the complainant's social media here in the military, where our complainant had alleged a sexual assault. And the following morning on her what is now X, what used to be Twitter, she made a very cheeky post. Guess what? Open paren, or who, close paren, I did last night. Winky face emoji.
Oh my.
We used a social media searching tool and found that, and it was time-stamped, and her profile bore her picture. And she came and testified about the horrifying sexual assault of the night before, only a few hours from the time of the post. And during our cross-examination, she had to answer questions about her social media post. So social media is now the lifeblood of prosecutions and prosecutors everywhere, but can be the life raft for defense attorneys. You're looking to confront what they believe are false, exaggerated, or misleading statements by complainants and other witnesses.
That's amazing. Camille?
Yeah, and in the chapter that we have an entire chapter dedicated to using and opposing social media. And we talk about, and we have the updated case law on emojis in court and how they're being interpreted, and judges' rulings on them, and how social media is being used to prove collusion or conspiracy. We talk about how to use it against them, as Kathleen talked about, and also how it can be exaggerated, and who is using the social media. Is it really the person whose account it is or someone else? And so it's a very, very vital chapter. And I think that we're kind of unique in that. I think our book really goes into it in depth, not just the social media itself, but also forensic cell site analysis, which is a new part of the second edition, because we deal with it on a day-to-day basis in our practice, and we are still practicing lawyers. And so this book is very up to the minute with that kind of evidence.
We should give credit where it is due. Professor Eric Goldman from Santa Clara University runs a website that updates as soon as new cases from anywhere around the country come out dealing with the admissibility of emojis in court. Professor Goldman's website will update anyone who's looking to find out what the state of the law is in their jurisdiction. And in the book, we explain that emojis are largely impermissible in court as evidence, something my lawyers here at the military learned from me after we wrote this book, because there is no uniform code, computer code, that allows the emoji to be displayed identically between devices. So if you have an iPhone and I am an Android user and I send you an emoji, it will show up on your Android looking different than the emoji I sent you from my iPhone, and vice versa.
That's interesting.
The courts have said that because of the disparity between the imaging and the failure of uniformity of regulation on the uniformity of those emojis, it muddies the water on the intent. Is the thing that you received on your Android, does it look like what I was trying to send you? And if the answer to that cannot be confirmed, then the emoji, the intent of the emoji and its admissibility fail. So Professor Goldman's website is very interesting, and we had put all of that into our book because if you can keep out the emoji of the face where the eyes are two X's, the government is trying to admit that, saying your client intended to threaten somebody. If you can knock those emojis out, this is a game of inches. And if you knock those emojis out of the hands of the government, you have gained an inch. And this, like I tell all my lawyers who are football fans, you don't have to run the football into the locker room to score a touchdown. The point of the ball needs to break the plane of the end zone. That's it. And so if you can do that by knocking down emojis and taking pieces away from the government, these are important inches to win. So that's why, like Camille's point earlier, this is a book that focuses on the very small details that pay off in an inch, an inch, an inch. And when you add inches together, this is how you break the plane. This is how you influence decision-making. This is how you win, not just competently lose by making a motion to suppress, then the motion gets denied, then you don't know that the emoji should be redacted, then they come in, then your guy gets convicted.
Oh my goodness, this is fascinating stuff. I love the whole social media aspect of jury trials, and the enthusiasm and passion of both of you in doing criminal defense work is contagious. So I want to recommend to everyone that they check out the Advocacy Excellence, the Jury Trial Second Edition Aspen Publishing book that you both have referenced and we've been talking about. And before we conclude, I just want to ask each of you to share for a moment or two what your predictions are for the future of legal education. You've both been to law school, you've both taught in law schools. Where do you think we're going in the coming decade?
Well, so I'm looking at it from the point of view of trial advocacy. I think it's terrific that there has been such an emphasis put on experiential learning. I can't tell you how many law students have said to me, this course, not that I'm so great, but that the trial advocacy course they took with me is the most valuable course they had because they learned some practical stuff. And I remember as a law student coming into legal aid and basically thinking, okay, I know the theoretical, but I don't know anything practical. And it was really, other than the criminal defense clinic, that was my first foray in practical law. So I think the experiential education thing is great. I'm afraid that there are too many lawyers who settle too many cases. And I'm afraid that people will look at the idea of a jury trial as a dinosaur Whereas for those of us who are in the know, who actually dip our foot into the water and plunge in to try a case, that it doesn't have to be that way. I'm afraid, and I think that a lot of law students and a lot of lawyers too look at trials as something that's already predetermined, that, oh, this is not a good case for me, so not going to try it. Or, well, it's 50-50. I mean, I don't even, honestly, I'm one of the only people I think I know that gives odds. Or I'll tell a client, you have a 60-40 chance of winning, or a 20% chance of winning, because I know how things go like that. But a lot of lawyers, if it's what I would call a triable case, will say, well, but what if I lose? Not because if you don't get into the water and try it out, you will never see how things can change, because trials are, and this is the one thing I want to really close with, trials are living, breathing organisms. They are not stagnant. This is not a script for a courtroom drama that you saw on TV, Law and Order, or whatever shows you want. Trials are dynamic. Things can change on a dime. Someone can throw you a curveball and you can hit it out of the park, or someone will surprise you with it. And it's not predetermined. The judge who you hated or hated you will listen to the case and suddenly change their mind and the rulings start going in your favor. You can actually make things happen. And I just think that I worry that a lot of lawyers and a lot of law students think of it as like canned food. And it's just not. So I worry about that. I'm glad we're doing the experiential education, but I really do worry about the lack of trials. I always used to tell young attorneys who are only doing misdemeanors, try every misdemeanor case, because at least it's a misdemeanor. What's the worst that can happen? Someone's going to get 3 years probation. Like, very few misdemeanor people go to jail. Try those cases so you see what it's like, because unless you've done it, you won't ever do it. So
Thank you. Kathleen?
I agree with Camille about all of that. And I also see that law school is going to move. The American Bar Association has moved. The bar exam is moving towards experiential. So the focus will be on more experiential learning. And hallelujah, right? Who wants a lawyer? When I came out of law school, I didn't know anything about being a lawyer. So the Legal Aid Society and all of the great good lawyers there practicing in anonymity taught me how to be a lawyer. And then I paid all of my student loans to Boston University School of Law. So go and you get an education, you come out and you don't know how to practice law. So it's kind of silly. So I'm actually glad that we're moving towards experiential learning. I think there are lots of sort of connections that I can see that are going to impact jury practice in the next couple of years. So for example, if you think about the current election cycle and you think about the push for voter registration for 18 to 25-year-olds. So the more 18 to 25-year-olds that you have registering to vote, the larger the jury pool, the potential jury pool comes, because jurors are selected from registered voters. So now you're going to have an old long in the tooth lawyer like me, who is trying a case to a jury that may skew younger than the juries that we are traditionally used to seeing. So you're going to have to inform your advocacy. And Jamie Puckle-Werble from Seton Hall Law gives a great training on sort of how to think and speak, like Gen Z, right? How to be young, hip, and cool, and how to communicate with them in the way that they learn. And so, lawyers have to inform themselves, advocates are going to have to inform themselves about how to connect with folks in different generations than their own. So I do think it's going to go more experiential. I'm also, like Camille, worried that too many lawyers back away from a trial. It's risky business. And I think our book is designed to sort of help people find the confidence that is required to step forward and actually confront the government's witnesses and confront their allegations. There are other books out there for sure that for time immemorial have said, do things a certain way. And I think when people pick up our book, they may find that there are suggestions in there that are different than what the traditional thinking would be about how do you structure a cross-examination, for example. Our book doesn't abide the common knowledge. Our book teaches cross-examination the way that Camille and I have learned that your listeners need to hear it in order to change their thinking. So our book is designed for what we hope are folks who are trying to summon the skill and the courage to step to the plate on behalf of a client and go to work in a courtroom and win.
Well, thank you both. I have really enjoyed this conversation. Camille Abate, still practicing as a trial attorney in federal and state court, doing criminal defense work, and Kathleen Mullin, who's the Deputy Director and Supervisory Trial Attorney at the Navy JAG DCAP, I'll say that. Both the authors of the second edition of Advocacy Excellence, the Jury Trial, through Aspen Publishing. I appreciate your candor and your insight about trial advocacy, the necessity for us to train our students at law schools in trial advocacy. I'm super proud at St. Mary's that we do that very robustly. And this year, our students have earned the ranking of #1 in the country by the American Bar Association. And these are skills that have to continue to be taught because they don't come naturally to a lot of people. So thank you for all that you've done to share what is in your book and what's in your trial notebook, if you will, your strategy notebook today. And I encourage people to take a look. Thank you.
Thank you, Dean.
Thank you.
If you enjoyed this episode and want to listen to additional thought leaders in legal education, you can find additional episodes on the Aspen Leading Edge podcast website or on your favorite podcast channels. Thank you.